So what if your biggest legal threat as a telemedicine company isn't bad care or malpractice, but the marketing plugin the dev team never told you about? In this week, we're diving into the class action lawsuits shaking the telehealth industry. So if you are legal counsel for a telemedicine company or guiding a platform that might be looking at, like, say, a partnership with pharma brands, this episode isn't optional, it's essential, and here's why. Well, your ad tech stack may already be leaking protected health information, or PHI. And if you think that the DOJ, the FTC, or plaintiff's attorney won't notice, think again. The latest lawsuits are being filed against major telehealth companies for allegedly sharing data with advertisers without proper consent. The claims are simple, but they are devastating. You're using tracking pixels, and these pixels then transmit personally identified health data to third parties. This could be a violation of HIPAA, possibly the FTC Act, maybe CCPA, and in some cases, actually a lot of cases, state consumer protection laws. And here's the kicker. That's not a glitch. That's how the system was designed. And you may be thinking, well, yeah, wait up. We anonymize data. The FTC has made it clear. Reidentification is easier than ever, and sharing data that even implies a sensitive health condition can cross the line. Now let's talk pharma. When a telehealth company partners with a pharmaceutical manufacturer, you are entering a regulatory labyrinth. Maybe HIPAA applies. Maybe the FTC oversight intensifies because of the advertising component. Maybe the FDA's promotional compliance rules may still apply, especially if a product is mentioned. Add in anti-kickback statutes if they're inducements, and you are stacking legal frameworks on top of legal frameworks, and each one comes with its own liabilities. And they don't cancel out, they compound. Let me give you an example. A pharma company directs potential clients to a telehealth company in this new DTP model, and they track progress. That data goes to Meta. Now Meta serves an ad from a pharma partner for that very product. That's not just very good targeting, that's possibly an unauthorized disclosure of PHI, a potential kickback, and potentially unapproved promotional claim. How did we get here? Now, this didn't actually just happen overnight. As telehealth exploded during the pandemic, I'd argue even before the pandemic, many companies rushed to scale. Growth meant adopting the same tools used by e-commerce giants, whether we're talking about analytics, retargeting, data enrichment APIs. But healthcare is not e-commerce. The moment you collect condition-related or disease-related information tied to a user identity, you may be in the land of protected health data. And regulators are finally catching up. It took them 5 years, but regulators are catching up. And class action lawyers, they're cashing in.
Enjoying our content? We'd love to hear more. Please like, comment, share, and find more.
So what should legal counsel do? First of all, you want to audit your tech stack. Find out what tracking tools are being used, are pixels or cookies being installed, who receives the data. Then, do users actually understand what's being collected and shared? Is the consent data granular enough? Then, you need to separate clinical from commercial. If your platform both provides care and sells products, your privacy architecture must reflect that. These aren't just operational silos, they're legal firewalls. Revisit your data sharing agreements. Do you have contracts with pharma partners or ad networks account for HIPAA? Do they include indemnification? What about audit rights? What about restrictions on reuse? You need to retrain your marketing team. Do your marketers know that they may be crossing lines? Educate them on the legal consequences of just installing a tag.
Find related podcasts below.
Now, let's talk about real-world consequences. What happens if you ignore these risks? There may be regulatory penalties. Office of Civil Rights can fine you for HIPAA breaches. FTC can impose consent decrees. Then you may be looking at civil litigation. Plaintiffs are suing for emotional distress, loss of privacy, and consumer deception. Reputational damage. Patient trust is being eroded. Pharma partners pull back. Investors get nervous. This isn't a future risk. This is happening right now. This is where we come in. At the Kulkarni Law Firm, we help FDA-regulated and privacy-sensitive businesses navigate these exact traps before they detonate. Whether you're a telehealth startup or a pharma-backed DTP platform, we provide the legal scaffolding you need, whether we're talking about privacy reviews, marketing compliance, data sharing agreements, and risk assessments. We want to help with all of that. Here's my question for you guys. Does your company use ad pixels? And if you don't, are you sure? Do your marketing and legal teams speak the same language? Are they talking to each other? What we find is that the marketing team is working really hard and the legal team is incredibly understaffed. Are you ready for a subpoena asking who received patient data and when? If any of this makes you nervous, you're not alone, but you do have options. If this episode made you rethink your tech stack, or maybe they gave you new ways to protect your company, please share it with your team. Don't forget to subscribe for weekly insights into the legal side of innovation. Until then, protect your partners, protect your platform, and above all, protect your patients. Visit us at the Kulkarni Law Firm at www.kulkarnilawfirm.com or reach out to us directly at darshan@kulkarnilawfirm.com or just info@kulkarnilawfirm.com. Stay safe, stay compliant, and next time, see you again on Deep Dive. Call, click, or email